We have a self-assessment system in Australia. What does that mean? It means that taxpayers and their advisors bear all of the responsibility for determining what their taxable income is. And in calculating that amount, knowing and reading and applying the relevant rules, and then remitting money to the tax office. It's important to note that very, very few taxpayers actually go and read the primary sources of law. Astute students of this subject would have heard me mention already that that's because in places the rules themselves are extremely hard to read, particularly in the 1936 Tax Act. However, as a result of taxpayers needing to apply the rules themselves, the taxpayers also bear the burden of getting it wrong. So as a result, the ATO and the Federal Parliament have developed systems and structures for the ATO themselves to be able to advise and give what we call rulings of what their interpretations of the rules are. It's important to note, though, that the ATO's interpretations, the rulings, and other systems that they use to publish their interpretations of the law are not primary sources in themselves. The ATO do publish extensively a variety of types of information. The important ones from our perspective are going to be rulings. However, in other situations, they can publish their own interpretations of what the laws are. They can make determinations that can have practical legal effect. They can release taxpayer alerts where particular issues have been drawn to their attention and they wish taxpayers to be aware of those things. Most, if not all, of the information the ATO wishes the public to see will appear on their website in some form, albeit difficult to navigate in places. The ATO also extensively publishes, so despite us living in an increasingly paperless world, the ATO will publish documents to assist in the interpretation of laws and in the filing of tax returns. The ATO themselves also have an extensive and comprehensive group of client engagement staff that can be contacted over the telephone or by email. Tax rulings come in two types. There are public rulings that apply to all taxpayers, and there are private rulings that are applied to a specific taxpayer. Now, the key thing about both sets of rulings is that they provide immunity for taxpayers who rely upon them. In the simplest sense, when the ATO issues a ruling about a particular issue or scheme, that will bind the ATO, but it will not bind the taxpayer themselves. In other words, the taxpayer can rely upon a particular ruling, but is not bound to do so. They can go and do things in different ways. However, the scope of the immunity for the ruling will only apply if the taxpayer falls within the specific scheme that the ATO is ruling about. It is important to note that rulings are not laws, and that a particular ruling that the ATO makes won't bind the ATO in terms of future decisions that the tax office makes. And if there are particular reasons, fundamental policy reasons, for the ATO deciding one way or the other in terms of interpreting the law and issuing a ruling, that's not going to bind them subsequently. A ruling will only bind the ATO in regards to what we call the scheme that is created in relation to. Public rulings are issued by the ATO where they think that there is a problem and that taxpayers, or a large number of taxpayers, are going to be confused or are misapplying a certain area of the taxation law. The key thing to note about public rulings is that they will bind anybody who falls within that particular scheme, that series of facts. But individual taxpayers can't ask the ATO to issue them. An individual taxpayer could ask for a private ruling in regards to the same matter, but can't force the ATO to issue public rulings that will apply to all taxpayers in that particular area. public rulings are going to apply to all taxpayers, or at least all taxpayers who fall within the scope of the factual situation that the ATO explains in the ruling, and who rely upon that ruling in terms of how they go and structure their tax affairs. There's no particular right to object to a public ruling. However, if you're a taxpayer who has a set of facts that fall within the scope of a public ruling, you can seek a private ruling on that same matter and then go through the objection process for that private ruling. There is a different type of ruling that a taxpayer or a collection of taxpayers can actually request that the Commissioner make, known as a product ruling. That is where either a taxpayer or a collection of taxpayers are entering into functionally the same transactions with or relating to a particular product, usually some form of scheme involving financial products, and they're unsure about what the tax consequences of this system is going to be. And so these product rulings can be applied by one or more, and they, as part of the process of application, will require a very high level of disclosure. You've got to explain the entire scenario, what you're planning to do to the Commissioner before they're able to go and issue a product ruling. Usually these product rulings will expire after 3 years. Another situation where you have multiple taxpayers seeking a ruling is what's known as class rulings. These aren't situations where taxpayers are looking at entering into certain types of transactions or entering into schemes or having products. Here, it's where you've got multiple taxpayers having the same problem, so to speak, in terms of interpreting the tax law. The idea is that the Commissioner can issue one of these class rulings upon application to really save a large number of taxpayers from individually needing to seek private rulings on a particular matter. As tax advisors, the most common and important type of rulings are private rulings. That is where a particular taxpayer essentially asks the tax commissioner how a particular provision is going to relate to a certain system, what we call a scheme. So basically a collection of facts. These can be done proactively in order to determine what the ATO's position is on a particular transaction or series of transactions that relate to a particular taxpayer. Private rulings have very wide scope. A person can apply for a private ruling in regards to any application of tax law. The Commissioner is obliged to create a ruling, but also note that Parliament can come at some stage later and override ATO binding rulings. So private rulings that have been put into effect, subsequently the law can be changed, but it can't be changed by the Commissioner themselves. So note that the ATO lacks the power themselves to retrospectively go and change the law in order to undermine a particular private ruling that's been made in the past. A couple of things to note about private rulings. The first is that the ATO is actually not allowed to make inquiries as to whether the facts or the scheme that the applicant has proposed is real, or if there are anything unusual, or if there is anything that might be factually incorrect as part of it. They're simply not, as part of the private ruling process, entitled to go and make their own inquiries. Now, the facts themselves that the applicant has put into the application can be real facts, so things that actually exist in the world. They can be future facts, things that might come to be, or they can be hypotheticals. They don't have to be real, actual sets of facts that exist in the world at the moment. But note that if you do put an application and you have unrealistic numbers in it, so you've got a scheme which is been explained in your application that really doesn't align with reality or what reality is likely to be, you won't be able to rely upon that. So that the applicant won't be able to rely on situations where the facts that they've put in it simply aren't realistic. When issuing the private ruling, the ATO isn't allowed to do any factual analysis of what is in the application. So functionally, they have to accept the facts that are explained in the application. That's what they rule to. They are not trying to read between the lines, and they're not trying to estimate what will actually happen. A private ruling must be based on the facts that are in the application. We call this the scheme, and that has a very broad definition. Note that, as previously mentioned, if the taxpayer puts a certain scheme into an application, obtains a favourable private ruling, but the actual facts themselves are different to what's in the scheme, then the ruling's not going to bind the tax office at all. There are some situations where the ATO is not obliged to make a private ruling. The first one is where the ruling itself would undermine the tax system entirely. So if it's going to unduly restrict the application of any particular taxation law, the ATO will decline to make a ruling. It's not that they're going to rule it in a certain way. They will just decline to create a private ruling at all. They also won't if the power is discretionary or if it's currently under consideration. And finally, the ATO won't write additional facts into an application. If the particular application for a private ruling is lacking certain facts, the ATO would have to make an assumption, then it simply will decline to make the ruling altogether. And note that when they do decline, they have to give reasons as to why they are declining, and that there isn't a right to appeal, strictly speaking, a decision by the ATO when they decline to make one of these private rulings. After a private ruling is issued, there's a couple of things to note. The first thing is that the ruling itself can actually only be relied upon by the person it was issued to. That even if a third party has facts which are materially similar, the ATO is not strictly bound by the ruling that they've issued to that one taxpayer. And to make this slightly more problematic, all private rulings are actually published. So the tax office goes through a process of de-identifying a particular ruling, removing all identifying features, and publishing that. They're quite clear in stating that that private ruling only applies to the one taxpayer who applied to it. It will not apply to all taxpayers globally. If you have had a private ruling that you don't like the result of, you can make what's called an objection to that private ruling. This is the first step in the process of really trying to determine whether or not this private ruling can be changed in some way to your benefit. So the first process is the objection step. And so that you can do this if you're dissatisfied with a ruling. That's the word that's used in the Act itself. It has to have some form of legal effect. So again, if you have sought a private ruling and it was for some hypothetical situation, you won't be able to object to it unless it's going to have some real effect as part of it. Now, when doing an objection, the Commissioner can actually rely on additional information when they're going through and determining whether or not the particular ruling was correct or not. And so if the additional information or the factual situation really demonstrates to the Commissioner that the reality is quite different to what the ruling itself was, or the facts that were set out in it, then the objection ends, the ruling stands, and the Commissioner can ask the applicant to apply for another private ruling because functionally it's a different set of facts. Again, if a person is still dissatisfied with the result of the objection, they can seek review through either the Administrative Appeals Tribunal or through the Federal Court. The vast majority of advice that the ATO gives is either directly through email and over the phone, talking to staff, or published on the website. Now, information that taxpayers and their agents receive in this way doesn't give them the same amount of immunity that they get from public or private rulings. However, if you take information from the ATO website or delivered from their staff members that hasn't specifically been stated as being non-binding, and you've reasonably relied on it in good faith, while you aren't protected from the substantive penalties in the taxation laws, you are protected against paying the additional interest charges. Basically, there's a scheme in place where if a taxpayer underpays, to create an incentive for people to not deliberately underestimate their income and then have to pay the shortfall amount afterwards, the ATO issues a compounding interest rate, which is quite high. That's made up of the general interest charge and the shortfall interest charge. And if you've reasonably relied in good faith on information that's come from the ATO that hasn't specifically been labelled non-binding, then you could be protected from paying that interest for the shortfall amount. Tax returns. It's a phrase that strikes fear in the heart of many. Now, a couple of things to note about tax returns. It's not a particularly exciting topic. Nonetheless, it's worthwhile to really know and understand how the process works. The first thing to note is that in Australia, while the population's about 25 million, each year there are significantly more tax returns that are lodged, the vast majority of which are done electronically. Most tax returns are lodged between the 1st of July and the 31st of October. But note that that's actually not a statutory rule. The Commissioner essentially determines what the date is and must publish that in a legislative instrument known as the Gazette. The Commissioner also, as part of their statutory powers, can map out how and where a particular taxpayer or class of taxpayers are required to do their tax returns and on which forms those must be done in. A really handy piece of information to know from a practical perspective is that if you aren't going to be able to complete your tax return by the 31st of October, tell the tax office ahead of time. The reason for that is that while they can extend the time in regards to a tax return, they actually don't have statutory power to retrospectively grant extensions as part of that. They can elect to simply not penalise you, but in regards to when the times and dates that are specified in the legislative instrument are, the Commissioner can't go through and extend your time after that particular date. So it may just be a handy thing to tuck away in your mind if you are having difficulties in late October completing tax returns, to go and seek a time limit extension from the Commissioner ahead of time. Much better to do that than to try and argue afterwards. You might be tempted to think, once you've gone through the arduous process of creating and submitting a tax return, that it's done and dusted, and you'd be mistaken. Why? The Commissioner has very, very wide, broad powers to compel any person, not just taxpayers, either to provide a return, to do another return, to make a more complete return, and to provide any other additional information about their affairs. And they can do this at any time. The overwhelming majority of tax returns that are submitted in Australia through the self-assessment system. What does that mean? It means that a particular taxpayer gathers information from the cells, completes the ATO's required form, and submits it. A couple of things to note about the self-assessment system. First of all, the vast majority of submitted returns are not closely checked. So by and large, if you submit your tax return through the self-assessment system, odds are good that the tax office is not going to go and examine the underlying facts underneath you've relied upon as part of doing your assessment. And so that this self-assessment system is very much grounded in trust. And as we'll see, that in situations where that trust is abused slightly, there are a lot of systems that the tax office can use, data matching and such like, in order to determine whether or not a particular taxpayer is, for example, going to be audited. But do note that that system, the self-assessment system, by and large works for the vast majority of taxpayers. Also note, as a small point, that it's not uncommon in situations where you've got no activity for a particular entity to submit what's called a nil return. For example, if you've set up a company but haven't started trading, it may be the case that you'll simply submit a nil return where you just write 0 in functionally all boxes and submit that into the commissioner. They also accept it if you just write nil in big letters across the return and post that in too. Just know that that is considered to be an assessment itself, even though you're assessed to pay no tax. One of the important legal points to note about assessment is the concept of finality. An assessment has to be definitive in order to be effective. So where in certain situations a tax office issues a tentative or provisional assessment, that's not going to be valid. It's also not going to be valid if there is what's called conscious maladministration in regards to a particular assessment. Now, proving that the tax office has actively, so willingly gone and maladministered a particular assessment is, as you could imagine, a very difficult thing to go and prove. So that doesn't come up very much. Also note that when the commissioner does make final, definitive and certain assessment, that component of finality is still considered to be valid even if there are certain statutory provisions, regulations that haven't been complied with. If the commissioner says that this assessment is final, it is final, even if certain processes leading up to that point aren't correct. The most common form of assessment is what's known as an ordinary assessment. That's where a taxpayer submits information to the commissioner in order for the commissioner to basically make the determination. Now, where you do submit facts to the commissioner, they can use the facts that you've supplied to them, or they can just disregard them. They're not under any obligation to take the information that you've supplied and use that as part of making the assessment for you. Now, it may be important to note that unlike an ordinary assessment, a deemed assessment is actually dated and deemed to come into existence and be definitive and final when it is lodged. So certain types of entities, companies, trust partnerships, and super funds are what's known as full self-assessment taxpayers. So the date that they lodge their return is the date that the assessment is deemed to have started at. It may just be important to note that, particularly if there are processing times, that's the point in time where, if you are one of those entities, that you're deemed to literally have assessed your taxation for a particular period. So just make note that the dates there can be quite a bit different where you are a full assessment taxpayer. And really the logic behind this is that not only will you be deemed to have had your assessment at that point in time, the time in which you have to pay tax goes from that period as well. So just make note that the rules for ordinary assessment and deemed assessment are slightly different in terms of those dates. The Commissioner has one of many powers that I've explained throughout this subject, a very powerful mechanism for issuing something called a default assessment. So a default assessment arises if a person just doesn't submit a tax return, or if the Commissioner is not satisfied with the return that they have submitted, or if they haven't submitted a return and the Commissioner thinks that they have actually derived taxable income. They can issue what's called a default assessment. And this is a little scary because the assessment amount is just what the Commissioner thinks it ought to be. In terms of the information that they gather as part of that, the Commissioner has very wide scope in order to issue these default assessments. When the Commissioner is issuing a default assessment, they look at your global income or make a guess as to what your global income might be, and they're not obliged to go through and carefully work out what your deductions would be as part of that. They also don't have any obligation at all to determine whether it's correct or not. They are making an estimate, and provided that they do so in good faith, you will be assessed as a taxpayer for the amount that the Commissioner thinks you ought to be paying. So if the Commissioner makes a very harsh or onerous default assessment, you think you'd have strong rights to appeal or to challenge that, and no, actually you don't. It's very, very hard to challenge default assessments. There's a very heavy burden of proof in that the taxpayer has to do more than prove that it's wrong. They actually have to prove that the amount in the assessment is excessive. And that's really challenging. It's a difficult thing to go and challenge default assessments. And you can kind of see in many cases why the Commissioner is afforded this strong, some might say terrifying power to issue these assessments. It's really to try and make sure that taxpayers essentially willingly submit their assessment on time and do it to the best of their ability. Also note that if you are going to go through the quite difficult process of challenging a default assessment, you have to still start with the objections process. So you first object, and then once the Commissioner has either issued a decision in regards to an objection or decided not to, then you can seek review. There are a few other types of assessment that the Federal Commissioner can make. The first is what is called a special assessment. That's usually done where a person has derived income for only part of a year. Usually this is going to apply primarily when people are about to become non-resident. So a person's derived income in Australia and they're about to leave. The Commissioner can issue a special assessment just prior to the person leaving. Also, this idea of it being for a part year can happen when a company goes into liquidation or a person becomes bankrupt, or if a natural person dies partially through a tax year. The Commissioner has a power called the Consolidated assessment. That's when a collection of people receive money on behalf of non-residents or people who aren't inside Australia. And so basically the Commissioner can issue an assessment against a person who is required to collect tax on behalf of those non-residents. That's the mechanism the Commissioner uses to make people who have withheld those amounts submit that to the tax office. Finally, there is in section 169 of the 36 Act, there is a catch-all. So basically the Commissioner can issue an assessment to a person if they don't fit within any of the other categories. Once a tax return has been submitted and an assessment has been made, there is a process that taxpayers can go through in order to change their return and thus change the amount that they've been assessed upon. Usually this will happen if a taxpayer discovers an error after the notice of assessment has been issued. And in that situation, the taxpayer can simply write a letter. There's actually no standard form to the Commissioner asking for a particular assessment to be amended. The Commissioner has power to go and amend assessments. They can do that in a wide variety of situations. The most common one, though, is upon being asked to by taxpayers. Now, occasionally, taxpayers will ask to change their amendments in order to pay more tax. There are certain strategic situations where that may come up, particularly where income has been allocated to the wrong tax period. But the vast overwhelming situations where a taxpayer discovers an error, it's usually for their benefit in order to go and have it amended, usually in situations where they've overpaid tax. Now, it's the ATO that does the amendments. As a taxpayer, you can ask the ATO to make an amendment, or if they discover an error, they can make amendments also. However, much like limitations of actions legislation that we have in other areas of law, we don't want people to worry about their tax returns from many, many years ago being amended, suddenly thrusting liabilities upon taxpayers here and now. So there are time limits, and for most taxpayers, it's actually pretty small. It's only a 2-year time limit for most taxpayers. It's a 4-year limit, though, where you're carrying on a business other than small business entities, so those that fall below a certain turnover amount. The 4-year time limit to amend also applies to trustees and beneficiaries, again, other than beneficiaries being small business entities. There is a 4-year time limit when there may be something to do with the broad anti-avoidance provisions, so the Part 4A anti-avoidance systems, and there may be 4-year time limits where there are certain types of taxpayers, and again the ATO has the power to prescribe these by regulation. So again, some of them are taxpayers with higher risk tax affairs, and they map out what that means, and who are at present revenue risk. The statutory time limits of 2 years for most taxpayers and 4 years for businesses, trust partnerships and such like don't apply in certain situations. So the tax office has unrestricted power to amend at any time, any return, if it is required to by the tribunal, that's by the AAT or by the federal court, particularly in situations where there is some form of process which is currently before the courts, and that's taken a long period of time, as they commonly do. The ATO is also given unlimited time to amend in certain particular situations under the statute itself. So distributions by liquidators, schemes designed to postpone liability, and certain R&D activities. And finally, in situations where there is fraud or evasion, the tax office has an unlimited time to go and amend a taxpayer's return. Also note that where an amendment is made, usually that resets the time limit for that particular taxpayer type in regards to that particular payments. The words fraud and evasion have different meanings in law. For the purposes of tax law, the word fraud actually uses the common law definition. This comes from an Old English case, Dairy and Peak. Basically, a statement is fraudulent if it's been made and one of these three things apply. Either the statement was knowingly false, so the person issuing it knew it to be false, or the person issuing the statement had no fundamental belief in the truth of the statement, or whether the person issuing it was recklessly indifferent. In other words, they didn't care. They put their head in the sand as to whether the particular statement was true or not. That's fraud in the common law, and that's the same definition that we use in tax law. Evasion, though, is really a creature of tax law itself. And Justice Dixon, as he then was, in Denver Chemical Manufacturing, and the Commissioner of Taxation of New South Wales, went and explained what evasion meant. And this explanation is still used in the tax law these days. Evasion, he describes it, is something more than merely avoiding or not paying or withholding information or furnishing, in other words, giving misleading information. It's something more than that. So it's somewhere between those things and an actual intention to defraud. So it's not as bad as fraud, but nonetheless it has some blameworthy act or omission that the taxpayer is responsible for. Okay, and the way the ATO look at that is it's making a statement which is wrong or taking an incorrect position without having any mechanism to explain it, without having any credible explanation of the position that you've taken or the statement that you've made. That's what the tax office holds evasion as being, and the courts follow that also. Because we have a self-assessment system in Australia, there would be an incentive for taxpayers to underreport their income or overestimate their deductions, or simply be late in paying the tax which is assessed to them. Now, the tax office for a long time and the federal government have been aware of this, and as such there is a system for charging interest in regards to these underpayments or late payments. The idea being that if you underreport and you're doing so not in a dishonest way, but nonetheless the ATO amend your assessment and you're assessed to pay more money at a later stage, the shortfall amount is charged, interest is charged on that shortfall amount. And the tax office will actually also, in situation where you've overpaid tax, pay interest back to you. Note that this underpayment where you get interest charged is going to be deductible. And even though it's not on the slide, an amount which is overpaid is going to, and the tax office pays you interest, is going to be taxable income as well. So no, both of those, even though they interact with the penalty system, they functionally operate as interest charged at differential rates. As part of the self-assessment system, it's not uncommon for taxpayers to need to make choices when doing their return. So, for example, you might recall that at the end of each financial year, the taxpayer can elect the system that they're going to use for valuing stock, their closing inventory. You get an election there. Now, under the self-assessment system, you make these choices, but while you have to record them and keep those records, for many decisions, you're actually not required to lodge them as part of the return. And the way the ATO structure their tax returns, the elections that you are required to lodge are included on the forms themselves, and other elections that you've made as part of making decisions for fulfilling your self-assessed tax return, you don't need to submit. Now, let's think of what in practical terms happens when you have submitted your tax return and the commissioner does an assessment, and you don't like it. Well, the first thing you need to know is that merely not liking a particular number often isn't going to give you enough information in order to assess what your options are at a particular point. And as such, we really need to talk in quite a great deal of depth about the system of actually obtaining information in order to strategically determine whether or not you're going to go through the objections process, and subsequent to that, whether or not you're going to pursue a review or an appeal on that particular objection. There's a couple of, I guess, general purpose legal rules that you would be wise to tuck away in your mind. And we'll start with Osmond's case, because Osmond's case basically said there is no common law right or general law right to obtain a statement of reasons from a decision maker wielding public power. So when a person at an institution, say James Cook University, makes a decision, you actually don't have a right to obtain reasons in regards to that decision and that decision-making process. However, that's under the common law. There are, however, rights under certain statutory systems. And so the two that we're going to look at are the Freedom of Information system, as well as rules under the Administrative Decision Judicial Review Act, the ADJRA. You can also use, or at least ask, the Inspector General of Taxation and Ombudsman to try and investigate a particular matter to obtain information. The IGTO has very wide-reaching powers to investigate and to report, and so they can be a mechanism for gaining information. However, they're not obliged to do so. So when you ask them, they can do it, but they're not obliged to as part of that process. It's also important to note for lawyers that when matters reach the courts, that you get the rights to obtain information from the other side. And so first, I guess, right that you get is the right to know what it is that the other side are actually claiming as part of this process, or if they're the respondent, you get the right to know structurally how they're going to respond to your particular claim. That's what we call particulars of a case. You also get rights to documents that the other side have through what's called the disclosure or discovery process. The tax office is an ordinary litigant, so if you're engaged in litigation, either the tax office bringing the action, or and so you're the respondent, or you bring an action against the tax office, they have both rights to obtain information from you, and you have rights as an ordinary litigant to obtain information from them as part of this discovery process. Right. Now we're going to look at the Freedom of Information regime. And I guess the starting point with the Freedom of Information, or FOI, system is that ultimately government departments and public institutions serve the citizenry. You as a citizen have rights in regards to what public entities do. And you as a citizen have a right to access information from public institutions. They serve you, not the other way around. That's the starting point with freedom of information, because the key thing to note is that when a person is using the FOI system, it's not strictly speaking about their own data. It's about data and information which is generated by public institutions, to which you as a citizen ought to have a right to see. Now, there are certain types of documents that public institutions are not obliged to essentially give out to the world. And some of them they're strictly allowed to withhold, they're strictly exempt. There are, however, a category of documents or types of documents where they are obliged by default to give out to members of the public who request them, unless it's not in the public interest. So this is what's called the public interest test. We'll have a look at these in a little more depth. So this first category of documents that you cannot get through the FOI process fall into one or more of these three categories. So the first one are documents that are held by intelligence agencies. So if ASIS or ASIO or a variety of the other security services have documents that they produce, they are exempt. You can't use FOI requests in regards to them. They aren't released, but they're released after 30 years, if at that time they're deemed to not pose any form of security risk to Australia. The second type of documents that cannot be released, or that are have what's called an unqualified exemption from freedom of information, are those covered by a legal professional privilege. So in situations where a legal advisor has claimed privilege in regards to a document or collection of documents, those you can't use FOI to obtain those. And the third one is where the material in the documents to be released has been obtained in confidence. So within the general law definition of confidential information. So the majority of documents that you seek under the Freedom of Information system fall under the conditionally exempt category. So basically, if a document falls under one of the categories that are listed on the slide, so if it's to do with deliberative processes, that's a pretty common one, business or professional affairs, or to do with certain operations of agencies, those are the main categories that government and quasi-government agencies use to try and argue that they ought not to be releasing documents. So once they've picked one of those, they also have to demonstrate that it's not in the public interest in regards to releasing those documents to an applicant. This public interest test, which applies uniformly, so it applies to all of these partially exempt categories, is basically a test of whether or not, on balance, releasing these documents is going to be contrary to the public interest or not. Now, the guidelines for this are issued by an independent body, the Information Commissioner. And for those that are interested in the Freedom of Information system, the Information Commissioner has a particular role where you wish to go and appeal a decision in a situation where a government agency has withheld documents, because I guess by definition, you can't go through an ordinary court system, because in order to examine the document to determine whether or not they are in the public interest or not, you would have to release the documents in a normal court system. So as a result, there is an independent agency called the Office of the Information Commissioner. They will examine the document to determine whether or not, on balance, it's contrary to the public interest if you do run into this situation. And note that the Information Commissioner also issues guidelines to agencies to help them and assist them in determining whether or not documents are contrary to the public interest or not. So, if a dissatisfied taxpayer has received their assessment and they don't like it, and they've obtained information in order to work out whether or not they wish to object to it, they can go through the first step. And this first step of challenging your assessment is the objection process. Basically, you fill in a form, you lodge it within the relevant time period, and the form that you complete has to have all of the grounds that you're seeking to rely upon in order to raise your objection. You are limited in terms of your time to object, and these time limits are actually quite similar, at least for the first two categories, to the time limits that you have for amendments. So again, for most taxpayers and small business taxpayers, individuals, small businesses have 2 years. So you, as the taxpayer, have 2 years in order to object, whereas more complex entities are actually given longer to go through and object to their particular assessment. And so that includes companies, trusts, partnerships, and super funds. All other taxpayers, though, rather than having unlimited time, they've actually got far more restricted time. So that if you wish to raise an objection and you do not fall within the simple categories and you're advising people, very importantly, this time limit for objection is a mere 60 days. It's much, much shorter than for the other categories of taxpayers. For technical reasons, the process of the Commissioner going through and doing an objection and the steps that they take and the determination they make, that process itself isn't capable of being reviewed in the AAT. And as such, there's actually no statutory right to reasons for them creating this determination. So just note that you get the right to seek review of the objection itself, but not the decision to make the objection. I know this sounds like a technical distinction, but again, for those who have studied a bit of administrative law, you may be aware that there are essentially all decisions from government bodies that are final and determinative rights you can seek review of in terms of both the judicial review and the merits review path. And so here, again, really for technical reasons, they've precluded you from doing that. That's not to say that the Commissioner won't give reasons explaining an objection decision, but there's no right to go to the AAT to grab those. Once you've received notification of the objection decision, that's when you can look at either doing administrative review or going through to the federal court for judicial review or the statutory appeal. Now, a couple of things to note, the things that are common to both is the burden of proof. So you have to bring the action, you have the burden of proof as the taxpayer. Also note that in terms of percentages, an outrageously small fraction of tax matters actually end up going through to litigation. Very, very, very small fraction. In 2019, the numbers listed there is that it's 1/1000% of matters that go through. So you note that even in situations where you have commenced litigation, either through the AAT in the tribunal system or through the courts, that most of those, the overwhelming majority, are also solved through alternative dispute resolution mechanisms before actually being finally determined by the AAT or the federal court themselves. When you're determining whether or not to go through the AAT or through to the federal court, it's helpful to know what each of those do and what they mean and what the powers of each of them are. Because the AAT is a tribunal. The idea is that the members on an AAT tribunal committee will stand in the original decision maker's shoes. So here that's the Federal Commission of Taxation. So they are stepping in and potentially remaking the decision properly. That's how the tribunal systems work for administrative appeals. And so because it's a tribunal, there's a couple of advantages, but also a couple of disadvantages that I really think are worth talking about, because this is an important part of legal strategy. So some of the great benefits of going to the tribunal is that the rules of evidence don't apply, at least don't apply strictly, because the rules of evidence are complex, a little arcane, and ultimately in the court system, that can end up being the determinative factor in many cases, particularly in the criminal law system. In tribunal systems, though, they're designed to be low cost and fast. So that's one of the real purposes of the tribunal system. So rules of evidence don't strictly apply, and because it's technically not a court in that it operates more of an inquisitorial model than an adversarial one, the tribunal themselves can actually empower themselves to ask questions. The tribunal are allowed to go and ask questions of the parties, and they can consider evidence that wasn't put before the commissioner originally. You can adduce new evidence as part of that. Another really important consideration is cost. The AAT is significantly cheaper than going through to the federal court, and also you don't usually have cost orders against a person. So you can go to the AAT by right, and usually you don't have to pay the other side's costs if you lose, so to speak. The AAT doesn't require lawyers. Now, in some situations where the matter is complex, it may be preferable for the sides to have lawyers, but by default, it's set up for you, as particularly as an individual taxpayer, to be able to go in and represent yourself. So the information and the procedural rights to obtain information actually is quite similar between the courts and the tribunal, and that you can go through the ordinary discovery and disclosure process. The staff, so the members of the taxation appeals division, have all got tax expertise. They're all going to know what the relevant laws are as part of it. But note that when they make decisions, that those decisions won't bind subsequent AAT decision makers. The what's called the doctrine of stare decisis just simply doesn't apply here. They're not binding precedents. And note that the AAT is going to be the final arbiter of fact. So it's only in very rare and narrow situations, if you don't like the decision, the AAT, that you can readduce or change evidence or facts in the federal court. So you can appeal a decision that you don't like in the AAT to the Federal Court of Australia, but only on questions of law. Strategically, it might be worth not going to the AAT and going directly to the federal court. Or, alternatively, you may have gone to the AAT and then you're seeking to then, assuming you don't like the result of your AAT decision, appeal it to the Federal Court of Australia on issues of law. Now, this is a strategic choice, that once you've got your objection decision, you can go down either path, and you can go to the AAT first and then to the Federal Court, but note, you won't be able to adduce more evidence to the court, to the Federal Court usually. And so, Federal Court is a court, so it has normal judicial powers, and that it has things, for example, to hold people in contempt of court for going and doing things that undermine the judicial process, or seek to embarrass or undermine the court system. The Federal Court don't have the ability to step into the shoes of the Commissioner. That's functionally not what they're about. They are determining the lawfulness of decisions, not the quality of the decision. That's a really important distinction. So they're not stepping into the shoes of the Commissioner. They are looking at the lawfulness of the decision itself. Another very important consideration in going to the Federal Court is costs, because in most court proceedings, the loser pays the winner's costs. And that's a really important consideration, because litigation is expensive. You can end up having to pay a non-trivial amount of money, in the case of tax law, to the tax office. You almost always need to seek legal representation and have them apply in court, again with subsequent increase in the cost of the proceedings. And very importantly, the rules of evidence apply. So the Federal Court rules are in application, and the rules of evidence apply too, so that you can't adduce things like hearsay. The court itself will not act in an inquisitorial mode. They're not going to make inquiries and ask the parties to adduce particular pieces of evidence. Their role is to sit back and let the two parties come together and them raise their arguments. Usually a hearing in the Federal Court will be public, and so that the taxpayer is going to be identified, and the public are going to know whether they win or lose. The doctrine of precedent applies, and thus a decision in the Federal Court of Australia won't technically bind subsequent decision makers in the Federal Court, but in the full Federal Court of Australia will bind subsequent decisions of the federal court, as will decisions of the High Court, because they're higher in the same hierarchy. Note also that by right, if you are dissatisfied with a decision in the Federal Court of Australia, you can appeal to what's called the full court of the Federal Court of Australia, where there will be multiple judges hearing your appeal, but it is only going to be on issues of law. So in situations where you've gone to the Federal Court directly after receiving your notice of objection, if you then want to appeal to the full court of the Federal Court of Australia, then it's only going to be on issues of law. Of course, if you've already been to the AAT, then gone to the Federal Court, you can only do that on issues of law anyway. And so that by right can be taken to the full court if you're unhappy with the result. Thus, when you're weighing up after getting your notice of objection decision, you've got to weigh up whether or not you're going to go to the AAT or the Federal Court. And it really depends what the matter is and what your client wants and what is going to be the best strategy for that client. Note that if it's something small, you're almost always better off going to the AAT because the cost consequences are much less, particularly if there are factual things in dispute. And there's going to be the discretion of the commissioner that needs to be examined. One of the things about the AAT is that because they step into the shoes of the commissioner, if the commissioner's weighed up some evidence against other evidence and preferred some over another, that by itself is not usually a ground for review in the Federal Court, but it is one where you might just get a better result if you're going before the tribunal. So the AAT is better for issues where there's discretion, for situations where you're really arguing the facts and you don't need the rules of evidence to apply. It's also best for smaller amounts where you've got less sophisticated clients. The Federal Court's better where it's the legal issues themselves that are problematic. So you've got disagreements, but they're really on points of law, not issues of fact. Or in situations where you think the rules of evidence might help you. That's a little less commonplace in tax matters because largely the tax office are pretty good at knowing what the rules of evidence are up to the point where they're litigating. And so that unlike dealing with other types of matters where you might get some sort of competitive advantage in terms of having the rules of evidence, often with tax matters that's not quite the case. Also for commercial certainty, where there are larger amounts in dispute and you've got access to a well-funded legal team, the Federal Court might be better in those situations, or more preferable to going to the AAT directly. Also note that if you have elected to go to the AAT and then you've decided to go to the Federal Court, that the facts are going to be locked in. And particularly in situations where the rules of evidence might benefit your client, you might be best to not go to the AAT first and take the objection decision and go directly to the Federal Court. So what actually happens when you get sent to the AAT? Well, again, because it's a tribunal, the AAT is designed to operate with as little formality as possible. We don't want the rules of evidence to overwhelm the participants because ultimately we want taxpayers themselves to be able to go to the AAT and have justice dispensed there without the need for formal legal representation. Now, by default, the hearings are in public, and so members of the public are welcome. Well, perhaps welcome's a strong word, but they are certainly capable of attending, listening, taking notes. Now, you can actually request, though, for a matter to be heard in private. Note that where the reasons for a decision have been generated for a private hearing, these will be structured in such a way as to not identify the applicants. The names will be changed and the factual situations, where need be, will be made a little bit opaque so that it's not immediately obvious who the applicant is. One of the things to note that while tribunals are not strictly speaking bound by the rules of evidence, nonetheless, they're going to try really hard to not adduce evidence that is going to create a different outcome from what the taxpayer or the tax office would get if they went through to the federal court. So while technically they're not bound by the rules of evidence, they're not going to let you adduce evidence that doesn't tend towards proving one of the matters at hand. They're not going to allow speculative things to be adduced and given weight in the tribunal environment. So that while they can inform themselves with things like hearsay, they're going to try to avoid it where possible if it's going to produce a different result in the federal court. Where the AAT hears a matter and makes determinations in terms of the facts of the situation, their determination is going to be final. And that if you don't like the results of the decision, you can appeal it to the federal court. But you're only going to be able to do that on issues of law. Now, while the AAT can and will make determinations that involve questions of law, ultimately, when they make a decision, it's not determinative. They're not a court. They're an administrative body. They're an arm of the executive arm of government. And as a result, decisions of law that are made by the AAT can always be appealed through the court system. Now, it is important to note here, though, if the AAT makes determinations of fact, that's the end of it. You will not be able to go to the federal court other than in very narrow circumstances and relitigate those matters. So the AAT itself is going to be the final point whereby facts are going to be determined if there is a dispute. I'm going to turn now to the system of law known as judicial review. It's really important from the outset for me to explain that judicial review is different from a statutory appeal. Judicial review is essentially using the court system to challenge unlawfully made decisions of the executive arm of government. Now, the ATO, as a government agency, will be making decisions all the time. And the federal court is the appropriate court, the Chapter 3 court, that a person who's aggrieved by a decision that's been made by the tax office can seek review of that decision itself. So note that the requirements we have here for judicial review don't actually apply, or rather you don't need to satisfy them in order to seek a statutory appeal from the AAT. You actually do not need to satisfy those. You can apply after you've gone to the AAT to the federal court by right. Here, though, we are looking at decisions that have been made by the ATO that can be a decision of an objection, but it also can apply more broadly to any decision that's been made by the tax office itself. This is the system known as statutory judicial review. There is another system known as common law, or in the federal system known as constitutional judicial review. We're not going to look at that here. Here we're going to look at decisions that have been made by the tax office themselves, and because the tax office is a statutory body, the decisions that they make are what's called of an administrative character made under an enactment. And that's the first requirement that you need in order to bring an action in judicial review. You must have this. A decision has to be made, must be of an administrative character, and it has to be made under an enactment. Now, there are some additional and more wordy explanations of that, but they're basically rephrasing this first line to do with conduct as opposed to a decision, and failure to make a decision, which also counts as a decision. So this is the starting point with judicial review. And look, this is a huge area of law. It's a very important area too. And for those that are studying this subject under an accounting major or anything other than a law major, this is probably your first and possibly last exposure to this system of administrative law known as judicial review. It's a very large area. It's a very important one in legal practice. And you can certainly arm yourself with information by going through the material here. And you may be able to make good use of this throughout your personal and professional lives. So what's a decision? Well, like anything in law, a word that has an ordinary meaning actually has a more particular technical legal meaning than would otherwise appear. So a decision for the purposes of judicial review is something which impacts or changes legal rights. In other words, it's a substantive decision rather than merely a procedural one, a series of steps towards reaching a subsequent decision which changes or confers or removes legal rights. That's an important characterization of what it is to have a decision capable of being reviewed. So this idea of a decision being the end result, it has to be final, it has to be determinative, it has to change someone's rights, either to give someone a packet of rights or to remove someone a packet of rights. It can't be a step or a chain in a series that leads towards the result. It has to be the result itself in order to be a decision capable of being reviewed. The purposes of our subject here, there are three things that you really need to be able to demonstrate to the court in order to obtain judicial review. The first is standing. You have to argue that you are a person aggrieved by a decision and that decision was of an administrative character made under an enactment. Now, we're going to assume that decisions made by the tax office are going to satisfy that. The second thing we need to establish is one of the grounds, and the third is a particular remedy. So when we're looking at grounds, you can't ask the court to overturn every decision for an arbitrary reason. You have to have a reason for having a decision by a decision maker, a public entity that's making a decision under enactment. You've got to have a reason for overturning it. And those reasons have to flow from some sort of error of law. And these fall into three categories. The first category is to do with what we call natural justice or procedural fairness. It's the idea that decision makers ought to be making decisions fairly. In other words, where they're making a decision, they have to give you, the person who's going to essentially suffer the result or have your rights changed, yet they need to give you the opportunity to adduce evidence, to know about the decision, and to be given ample time in order to respond to these things. We think of natural justice, and this flows from the concepts we have in the criminal law, this right to hear the charges that are placed before you. And this also applies in the public law sphere as well. If your rights are going to be impacted or affected, you've got a right to know about it. You've got to you've got to have this right in order to be able to adduce evidence and to obtain these reasons as part of it. That's natural justice. The other component of natural justice is actually the right to have an unbiased arbiter. So this would apply, again, in pretty narrow corner cases. If the particular person making a decision had an interest in the outcome, again, that's pretty rare that comes up. If a person happens to be on the AAT or happens to be at the tax office who knows you or would benefit in some way from deciding one or the other, that's pretty rare. But that is the other component of natural justice. All right, the other two broad areas are what's known as what we call narrow ultra vires and broad ultra vires. This idea of narrow ultra vires is essentially when a decision maker makes a decision where they're simply not authorized to do that. So that they've exceeded their power that's been given to them under the statute. And they've done it in a very clear and obvious way. In situations where that arises, it's usually pretty straightforward to obtain a remedy. You have to demonstrate what the relevant statutory power is, adduce the evidence that the person's exceeded that power, and then obtain a remedy. People aren't allowed to make decisions that affect others if they're not given power through statute to do so. Now, this usually is expressed through the Commissioner's power to regulate, so to pass delegated instruments. And in those situations, it's one of the mechanisms you can use to challenge decisions is that the empowering legislation, in other words, the statute that the Commissioner is relying upon to make delegated instruments, that they've exceeded the power that was given to them by Parliament. That's one mechanism you can use to make an argument that that falls under what we call narrow ultra vires. Now, all of the other categories that we've got here, we usually describe these as what's called broad ultra vires. So that is where a person is acting within power, but they haven't used that power either lawfully or reasonably. And so these are usually a little harder to prove. And so one of the common ones is here I've listed them as items 3 and 4 on this slide. It's what's called an improper exercise of power, where a decision maker has taken into account irrelevant considerations as part of making a decision, or failed to take into account relevant considerations when making a decision. Now, this sounds like we're looking at the underlying quality of a decision, but it's actually not. These are issues of law. These are things that a decision maker in situations where the statute says they have to take certain things into account, or they're required to not take certain other things into account, in some way they've acted unlawfully. And so we can use that as a ground for seeking review on their action. You can also do it in situations where there is no evidence to justify that making. In other words, they've made a decision, but there's no evidence to justify that particular decision. Now, there is another couple of areas here, things that are otherwise contrary to law or errors of law, expressed in the broad sense. But the last one I want to talk about is the unreasonableness. This is also known as Wensbury unreasonableness after the UK case that this flows from. It's basically this concept that a decision maker has exerted their power, but they've done it in such an illogical or irrational way that no reasonable decision maker could ever make their decision in that way. That's what unreasonableness is. It's actually a pretty high bar. This is one of the more difficult things to prove because it sort of almost blends the boundaries between making determinations of fact or merits review, which normally would be done by the tribunal, as opposed to the courts. Remember, the courts are only looking at issues of law. They're not looking at the underlying quality of the decision, unless it is so unreasonable that no one could ever have reached that conclusion because it's been done in such an illogical or irrational way. Now, if you have established standing and you have established one of the grounds, in other words, demonstrated that the decision maker has acted unlawfully in some way, that breached procedural fairness or acted beyond their power or somehow used their power in an unlawful way under one of those grounds of judicial review, you can then ask the court for a remedy. And the remedies that are listed in the ADJRA are very broad. And so the federal court, for example, gets the power to suspend the decision. They can stay any of the proceedings that decisions currently that are underway currently as part of that decision. They can set aside it, and they can refer it back to the decision maker for reconsideration. And they can give directions as to what this reconsideration can or cannot entail. Very importantly, though, the courts are not making the decision. That would be a bridge too far. It's actually a breach of what we call the separation of powers doctrine. Courts are not administrative decision makers. They can examine the lawfulness of decisions and they can send it back to the decision maker to get them to remake it, but it's technically not the court themselves making it. Now, some other orders the courts can make are what's called declarations. So they can declare what the rights of the parties are and say ahead of time that if a particular matter is going to come before the court is going to decide it in a certain way. Now, strictly speaking, the tax office isn't bound by that, but they'll follow those decisions of the courts because it would be futile not to, because the taxpayer is basically going to be able to rock up to court and have that matter heard and decided the way that the court has previously declared the rights of the parties to be. So these are what's known as the remedies that you can seek for judicial review. One thing to note from a procedural perspective is that earlier I've mentioned that you can't obtain statements of reasons in a variety of circumstances. However, if you do have standing to seek a remedy in judicial review, you actually can obtain reasons from that particular decision maker. And those reasons have to be set out in a certain format. They have to be clear, unambiguous, express the basis of the decision by demonstrating and explaining the relevant facts they've used to make that decision, and explain the law and how they've applied it to that particular situation. The tax office itself, when it's conducting litigation, has an additional series of, duties placed upon them because they are what's known as a model litigant. The Federal Parliament has mapped out a framework for government agencies that explains how they ought to go about conducting litigation, because ultimately the ATO has a very large pool of legal resources and expertise that they could use to dominate proceedings against individual taxpayers. And as such, these model litigant set of rules are things that guide the lawyers for the ATO in terms of how they conduct proceedings. Another thing to note is that the ATO will, from time to time, have test cases. So situations where they genuinely don't know what the law is, or they've determined it in a certain way, but they're not sure that the courts will do the same. And in situations like this, the ATO will have what's called test cases. And the key thing to note here as taxpayer is that where there is a test case, the ATO will fund it. So the ATO will fund your legal costs as well as not seek costs for you, because the purpose of these test cases is for a publicly demonstrated decision from the courts, and that's arguably in the public interest. So as a result, they pay for these test cases to be litigated. If you don't like decisions that have been made by the AAT or the federal court, you do have certain rights to appeal. And so the systems of appeal are mapped out in statute. If you don't like a decision in the AAT, you can appeal to the federal court, but only on issues of law. So you can't re-litigate issues of facts that have been adduced. So if the tribunal determine factual matters, that can't be reopened in the federal court itself. If you have one of these appeals that has gone to the federal court, or in fact if you've had judicial review which has been done by the federal court and you don't like the outcome of that, you can make an appeal to the full Federal Court of Australia. That is going to be heard by either 3 or 5 federal court judges, and they will look again at the lawfulness of the original judge's decision. If you don't like that decision, you can try and appeal it to the High Court. However, the High Court is not really an ordinary court of appeal. It's certainly not by right that you can go to the High Court. In fact, it's very, very rare that the court will grant leave to appeal. It has to be something fundamentally important to the common law of Australia that will essentially let you go to the High Court and have your matter heard. It's quite rare that happens in tax matters. And so while there is that option to try and seek leave, it's extremely rare that tax matters actually end up before the High Court for them to determine an appeal. There is a system which is different and distinct from seeking appeals or reviews through the tribunal or through the courts. And that you can just simply go to the Ombudsman. You can go to the Ombudsman and make a complaint. I have mentioned a few times throughout the subject that complaints really don't have any legal force. And so if you are in situations where you are making a complaint about something, note that that's quite a different kettle of fish, so to speak, than an appeal or a review of a decision. There's no real aspect of law that comes into this. So you can ask the IGTO to investigate a decision that the tax office has made, but firstly, they're not under any obligation to investigate. They can do, or they can choose not to. And even if they do investigate and they determine that their ATO has done something wrong, they can't do anything about it. They can only report what they've found. They can't force the tax office to go about doing a particular course of action or to make a decision in a certain way. So it's important to note that if you do have some form of complaints, there is a system whereby you can voice those and you can get them investigated, but there is no fundamental legal consequence to doing so.